10. Making law with rules and standards. 10.1. The basic distinction. In most American states, the law instructs family court judges to make determinations about child custody and visitation rights in such a way as to further the best interests of the child. The judge is expected to take testimony about the facts, hear argument, and then make the decision that in his relatively unconstrained discretion will promote the best interests of the child, as opposed to, say, the best interests of the parents or the best interests of society. Similarly indeterminate is the Fourth Amendment to the Constitution, which provides that the right of the people to be secure against unreasonable searches and seizures shall not be violated. Courts applying the Fourth Amendment thus find themselves with a task of deciding what constitutes a search, what constitutes a seizure, and especially which searches and seizures are to be considered unreasonable. By way of contrast to open-ended legal terms like best interests and unreasonable, consider the specificity of the regulation under the Occupational Safety and Health Act requiring that on all construction sites with more than 20 and fewer than 200 employees, there shall be no less than 1 toilet seat and 1 urinal per 40 employees. In much the same way, a Securities and Exchange Commission rule promulgated under the Securities Act of 1933 directs registrants to file 3 copies of the complete registration statement on good quality, unglazed, white paper, no larger than 812 x 11 inches in size. And Article Roman III of the Constitution mandates that no person may be convicted of treason unless on the testimony of 2 witnesses to the same overt act. The difference between the former set of provisions and the latter should be obvious. The first group, including language such as best interests and unreasonable, is broad, vague, general, and imprecise. The second group, with its use of terms like more than 20 and unglazed white paper, is detailed, specific, concrete, and determinate. Conventionally, the difference between the 2 groups is described as a difference between precise rules, such as more than 20, and vague standards, such as unreasonable. The distinction between rules and standards appears everywhere, and no discussion of legal reasoning would be complete without a careful consideration of this centrally important distinction. Although rules such as the ones set out above are highly precise, and although the standards just described are vague in the extreme, the difference between rules and standards is actually a matter of degree. Or, to put it differently, the extreme of vagueness, the best interests of the child, or unreasonable, is close to the vagueness standards end of a spectrum, and the extreme of precision, 2 witnesses, white paper no larger than 812 x 11 inches in size, is close to the precision rule's end. In between these extremes, there is a continuum, on which some legal directives are more at the rule's end and others closer to the standard's end. Drive prudently is pretty clearly a standard, and speed limit 55 is equally clearly a rule. But slow down for children, yield to oncoming traffic, and lights on at dusk are all somewhere in between. Located more or less midway between the Constitution's requirements of 2 witnesses to convict for treason and the minimum age of 35 to serve as president, on the one hand, and the prohibitions of cruel and unusual punishments and unreasonable searches and seizures on the other, are the Seventh Amendment's guarantee of a jury trial in suits at common law, and Article I's prohibition on bills of attainder. Accordingly, rather than thinking of a distinction between rules and standards, it might be better to think of a location on the vagueness-precision continuum, and how vague, or how precise, may be far more useful questions to ask than whether some directive is more like a rule or more like a standard. 10.2 Rules, Standards, and the question of discretion. The rules-standards continuum is important for many reasons, but foremost among them is the way in which selecting the point on the spectrum can be a highly effective device for the management of discretion. Discretion is, of course, a central concern of the law. Under what circumstances will which officials be given the freedom to exercise their own judgment and make their own choices? And under what circumstances will that freedom be constrained or even mostly eliminated? When a judge is determining which custody decision is in the best interests of the child, for example, she might be faced with a choice between a wealthy mother who can provide the child with high-quality education, housing, recreation, and culture, and a less wealthy father, who appears to understand the child better than the mother. Under these circumstances, some judges would prefer the mother and others the father. But the basic idea of discretion is that neither of these decisions, given the best interests of the child standard, would be legally incorrect. People might criticize one or the other decision for being morally wrong, psychologically ignorant, or based on erroneous factual premises. And so it would not be correct to say that the two decisions are equally right. But it would be correct to say that the two decisions are equally legally right, and thus that either decision would, in the ordinary course of things, be upheld on appeal. By contrast, if instead of the best interests of the child standard there existed a rule stating that custody was always to go to the wealthier parent, then a judge would no longer have the discretion to award custody to the less wealthy, but more caring parent, and we would expect that a decision to do so would be overturned on appeal as outside of the judge's discretion. This idea of discretion has many different labels. Sometimes it is called leeway, sometimes it is seen as a variety of deference, and in European community law and European human rights law, and sometimes elsewhere, it is referred to in terms of a margin of appreciation, the latitude that member states are given in making their own judgments about matters ultimately controlled by European law. But regardless of the label, the idea of discretion is that some institution with the power to control or review will let stand a multiplicity of quite different decisions, including some that the controlling institution might think wrong. Just as the no vehicles in the park rule may permit a judge discretion about whether to include or exclude bicycles, skateboards, and baby carriages, so does any other official with discretion have the power to make any one of a number of different decisions. Analyzing the idea of discretion is not our primary goal here. But from the perspective of the devices of legal reasoning, it is important to appreciate that a common way of granting discretion is to couch the governing law or regulation as a standard. When Montana eliminated its numerical speed limit for a few years in favor of the vague requirement, a standard that driving be reasonable and prudent, it gave police officers the discretion to decide what speeds under what conditions were reasonable and prudent, and it similarly gave to traffic court judges much the same discretion. The Montana Supreme Court subsequently ruled that reasonable and prudent was too much of a standard to support a statute that provided for criminal penalties, but the basic idea here should be clear. When a directive is expressed in broad and vague terms, it grants discretion to, and thus empowers not only those, like police officers, who are charged with enforcing the directive, but also those, like judges, whose task it is to interpret it. Conversely, therefore, the use of directives at the rule's end of the continuum can be understood as a device for constraining or withdrawing discretion. If a filing deadline for, say, the signatures necessary to put a candidate on the ballot is 5 p.m., the official who decides whether to accept the filing has far less discretion than would be the case if the requirement were only that the filing be timely or sufficiently prior to the election as to permit the ballots to be printed. Similarly, Article 351 of the Constitution of South Africa provides that everyone who is arrested for allegedly committing an offense has the right to be brought before a court as soon as reasonably possible, but not later than 48 hours after the arrest, or the end of the first court day after the expiry of the 48 hours. If the 48 hours expire outside the ordinary court hours, or on a day which is not an ordinary court day, this provision is, to put it mildly, vastly more precise than the American counterparts of mandating a speedy trial in the Sixth Amendment and due process of law in the Fifth. And this should come as no surprise. Police, prosecutorial, and even judicial abuses of power were widespread in the apartheid era, which ended with the 1995 enactment of the new South African Constitution, and we can thus appreciate a reluctance at the time. The Constitution was drafted to grant discretion to mostly the same police officers, prosecutors, and judges who had been in power during apartheid. And even after the makeup of officialdom began to change, we can still understand the residual skepticism about official discretion in the criminal justice system. This skepticism about official discretion would naturally lead to the choice of rules over standards, and the highly specific provisions quoted above are the consequence of just this skeptical attitude. Skepticism about discretion is not always a function of distrust of officials. Sometimes we worry about excess discretion because we are concerned with the lack of predictability that too much discretion will bring. If I want to know how fast I can drive, being told that I must drive reasonably and prudently will not answer my question, any more than being told that I must not enter into contracts in restraint of trade will help me to know how to comply with the antitrust laws. Indeed, this is one of the reasons why the Supreme Court has traditionally created so-called per se antitrust rules, under which schemes such as price fixing, resale price maintenance, and tying arrangements were understood to violate the Sherman Act without regard to their economic effects in the particular case. Some of these per se rules have been eliminated or weakened, but the basic point persists that a per se rule is likely to give far more information about likely consequences of action than a less determinate standard. Sometimes we wish to constrain discretion simply in the service of efficiency. A food inspection official at a border customs station can make a quick determination of whether a product being carried into the country is or is not meat. But if the same official were empowered to determine on a case-by-case basis whether a product was unsafe or unhealthy, he might have far less time to watch out for drug couriers and terrorists. Not only do precise rules require officials to spend less time on routine decisions, but they also allow the designers of decision-making environments to employ people with less skill or experience. Deciding whether a certain kind and level of factory waste dumped into a river is harmful to the environment probably requires an experienced environmental expert. But deciding whether the concentration level of a certain chemical is above or below a specified number can far more easily be entrusted to a less experienced and less well-trained technician. Although these efficiency concerns are important, the use of directives toward the rules end of the rules standards continuum will typically be a product of a determination that making individualized judgments in each case will produce too many unacceptable errors. That was the impetus behind the federal sentencing guidelines, a highly precise and constraining sentencing system, since softened somewhat by the Supreme Court, intended to replace a regime of sentencing discretion that had generated wide disparities in sentencing for the same crimes. The use of vaguer directives at the standards end, conversely, will typically reflect a judgment that individualized or case-by-case determination is what is most important, preferring to endure the errors of individualized judgment to the errors that will come from the over and under-inclusiveness of rigid and precise rules. Indeed, something like this goal is what led the Supreme Court to make the federal sentencing guidelines somewhat less rule-like. But there is no strategy that will be best in all contexts, and thus the lesson may be that the determination of how much officials should be allowed to look at the particular context of a particular instance, how much the official should be operating under a standard rather than a rule, or vice versa, will itself be a contextual determination. 10.3 Stability and flexibility. It is true that location on the rules standards continuum is an important way of allocating discretion between the issuer of the directive and those who must apply it, enforce it, or interpret it. But the difference between rules and standards is also a way of allocating decision-making between the present and the future. When a legislature, agency, or court sets forth a rule, it is making a decision now about what is to be done in the future. And when instead it moves toward the standards end of the continuum, it holds things open for the future and allows for a flexible approach to the problems of tomorrow. Accommodating to a future that we can at best dimly perceive is a recurring problem in the law, and one that is almost certainly growing. With respect to rapid changes in electronic communications, for example, any attempt to write specific laws at this time is as destined to obsolescence as were those specific rules of only a generation ago that did not and could not have anticipated widespread cell phone usage, the development and dominance of the Internet, and a density of satellite-based communication technologies that makes a list of communications media limited to radio, television, and motion pictures seem archaic. So too in many other areas. Developments with respect to cloning, genetic modification, DNA identification, and much else will almost assuredly doom to failure, or at least to predictable obsolescence. Any attempt to use the scientific knowledge of today as a basis for the categories of the rules that we expect to have effect in the future. Just as the location of the rules standards continuum can help to allocate discretion, therefore, so too can it allocate decision-making authority between the present and the future. A communications regulation that is drafted as a highly specific rule, and that therefore inevitably draws on current and not future knowledge, allocates power today to determine outcomes in and for an uncertain future, while a much vaguer standard medium of communication, for example, would let the future make decisions for itself, but at the cost of less guidance and less precision for the present. The allocation of decision-making authority between the present and the future thus presents the fundamental trade-off in the question about rules and standards. Highly specific directives rules will maximize certainty, constraint, and predictability, but they will do so at the cost of retaining the ability to achieve exactly the correct result in some currently unanticipated case or situation. And much vaguer directive standards will hold open the ability of some future decision maker to make just the right decision, assuming for the sake of argument that that decision maker will in fact do so, but at the cost of providing very little certainty, predictability, and decision maker constraint. There is, to repeat, no right solution to this inevitable trade-off. Nor can it be said that one or another approach is more or less consistent with the values of the rule of law, because although some rule of law values are served by precise, predictable, and understandable rules, others are served by relatively open-ended standards that will allow judges and other official decision-makers the discretion to do justice in the individual case. But although there is no easy or consistent answer, understand, in the way in which the rules standards continuum is a valuable tool for allocating authority among officials, allocating decisions between the present and the future, and allocating our concern between predictability and individualized justice will enable participants in the legal system to understand one of the most important devices of legal and regulatory institutional design. 10.4 Rules and Standards in Judicial Opinions. The distinction between rules and standards is central to questions of legislative control and administrative discretion, and thus it is common to think of rules and standards in terms of the degree of specificity and vagueness in a constitutional provision, in a statute, and especially in an administrative regulation. But judicial opinions can also be sources of guidance, command, and authority, and as such they are equally susceptible to analysis in terms of the extent to which the guidance offered by a judicial opinion is more or less like a rule or a standard. Consider, almost at one extreme of the rules-standards continuum, the Supreme Court's 1966 decision in Miranda v. Arizona, in which the court held that the Fifth Amendment, either directly, with respect to the federal government, or through the 14th Amendment, as applied to the states, mandated that a confession or other statement by a suspect subject to custodial interrogation could be used against him only if the suspect had been warned of his constitutional right to remain silent as well as his right to a lawyer. Having reached this conclusion, the court could have announced what was in effect a standard for the lower courts to follow in evaluating subsequent claims under Miranda. The court could have said, for example, that a confession or other statement will be admissible if and only if it is found that the statement had been made voluntarily. And it could have made clear that the determination of voluntariness was a contextual judgment that should consider all of the circumstances in which the statement had been made. Or the court could instead have said that statements taken unfairly or unjustly or coercively would be inadmissible, again leaving it to lower courts in particular cases to decide in light of the circumstances whether a statement was taken unfairly, unjustly, or coercively. Had the court proceeded in this way, by the use of these kinds of flexible, contextual, and vague requirements, we would have said that the court had elected to set forth a standard to be followed by the police and lower courts alike. As is well known to viewers of television and movies, to say nothing of lawyers and judges, the court did not proceed this way in Miranda. Instead, it told police officers more or less exactly what to say. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to a lawyer. If you cannot afford a lawyer, one will be appointed for you. If the police did not say something pretty much exactly like this prior to a custodial interrogation, the court emphasized, any statements made by the suspect to the police would be excluded from the trial. And in deciding whether the police had acted consistently with the requirements of Miranda and the Fifth Amendment, lower courts were charged with determining little more than whether the police has uttered something very close to these magic words. The Supreme Court's actual approach, therefore, was very much a rule-like one. The court told the police and the lower courts exactly what they should do. And it is remarkable that police officers now essentially read from a Supreme Court opinion when they are interrogating a suspect. The words on a so-called Miranda card, the text that police officers carry with them and read aloud to those they have apprehended, are almost word for word taken from the Supreme Court's opinion. And in so laying down exactly what police officers should do, the court acted very much like a legislature or highway department, deciding that drivers should drive no faster than a posted numerical speed limit, rather than telling drivers that they should simply drive prudently or carefully or reasonably. It is controversial whether courts should proceed as the Supreme Court did in Miranda, or as the court did in Roe v. Wade when it set forth the precise trimester approach to the restrictions that states might permissibly place on the right of a woman to an abortion. For some critics, laying down detailed rules is for a legislature, and a court exceeds its authority and goes beyond the particular competence of a court when it does things that look legislative. But this criticism seems odd, at least if we assume that other courts, policymakers, and ordinary people should be guided by what the courts have done. If we think that courts are only in the business of making decisions for the parties, then perhaps it is not so bad that others cannot be guided by those decisions. But especially for the Supreme Court, which these days decides so few cases, such a view of the court's role seems as inefficient as it is unrealistic. There are rules that are addressed to courts and purport to tell courts how to decide cases, and there are rules that are addressed to the citizens and officials who wish simply to know what to do, and judicial opinions that resemble the directives at the rules end of the rules standards continuum are often quite plausibly focused on providing a source of guidance for citizens and non-judicial officials alike, especially where a judicial opinion deals with conduct that is repeated daily by numerous individuals. Rule-like precision brings the virtue of providing reasonable advice to large numbers of people, and the advantages of doing so may often outweigh the disadvantages that come from relinquishing standard-like flexibility. Joining those who criticize courts when they issue rule-like directives are others who have argued that appellate courts should decide only one case at a time, often insisting that this is what courts do best, or that this is the only thing that courts legitimately ought to do. The question of legitimacy may be somewhat remote from issues about legal reasoning and the rules standards continuum, but not so for the other dimensions of the argument for deciding one case at a time for deciding a particular controversy and not setting forth broad prescriptions for deciding others. And one argument for this approach is that making decisions that in effect decide cases, not before the court requires fact-finding capabilities that are beyond what we can expect in the appellate process. When a court decides an issue broadly, when it decides that all custodial interrogations by all police officers of all suspects under all circumstances must be preceded by a warning of the kind the Supreme Court delineated in Miranda, it is in effect deciding a whole bunch of cases, but in the process it is required to guess about what those other cases might look like. It is likely, for example, to assume that many of these other cases will look like the case before it, an assumption consistent with what psychologists refer to as availability, the belief that that which is most cognitively accessible to us is representative of some larger class of acts or events or cases. But often the facts on which an appellate court must focus are not at all representative, and to that extent making broad rulings in the context of concrete cases may not be the best way to lay down broad principles of law. Once again, there is no right or wrong answer to the question of whether appellate courts should lay down broad rules in the process of deciding cases, or whether instead they should focus on producing the best answer for the case at hand, leaving other cases for other occasions and other decision makers. The decision about how much to decide, however, and thus of how much law to make, it is far too late in the day to think that courts do not make law, is much like the distinction between rules and standards. It involves the allocation of decision-making authority among potential decision-makers. It involves the assignment of decision-making responsibility between the certain present and the uncertain future. And it involves the pervasive tension between the advantages of flexibility and the competing virtue of letting citizens, officials, lawyers, and other courts know what the law is, even if the law they know may not always be the best law that could be developed for every individual dispute and every particular act. 10.5 On the relation between breadth and vagueness. We commence this chapter by describing the conventional distinction between precise rules and vague or indeterminate standards, and we have moved gradually to the question of whether courts should issue broad rulings or narrow ones. This is the appropriate place to point out, therefore, that the scale of broad to narrow has little to do with the scale of precise to vague. We can start with a simple example. Take the category of insects. It is a huge category. In the first place, there are lots of insects. Trillions of them. Lots more than there are mammals, fish, and birds combined. And there are lots of kinds of insects. Again, there are far more species of insects than of all the other members of the animal kingdom put together. Yet, although there are lots of insects and lots of kinds of insects, the category of insects is very determinate, and so is the word insect. Like any other word, it is not perfectly determinate. And there are certainly contexts in which we can imagine struggling with whether a toy insect or a dead insect is really an insect, just as we would struggle with whether a bicycle or a skateboard is a vehicle for the purpose of the no vehicles in the park rule. Yet for the category of insects, the proportion of borderline cases is very small. It is not non-existent, but it is much smaller compared to the class of non-borderline cases than would be the case for vehicles, say, or for schools, or, to take an example made famous by the philosopher Ludwig Wittgenstein, for games. What the example of insects teaches us, therefore, is that broad categories can be extremely precise. And of course narrow categories can be vague, even though there are far fewer cases of heroism than there are insects. And though most people would agree that heroism is quite rare, the term itself is highly vague, and there would be little agreement about what counts as a heroic act and what does not. In law, the distinction between the precise and the vague is largely a question about discretion, a question about flexibility, and a question about the competing aims of predictability and individualized justice. And the distinction between the broad and the narrow is largely a question about how much courts or legislators or other rulemakers should do when they are deciding a case or laying down a rule. Both the distinction between the broad and the narrow and the distinction between the precise and the vague, and both, of course, are questions about a place on a continuum, and not simply about one thing or another, are important. But they are not the same. A court concerned with not deciding too much, but also concerned with giving guidance, might, for example, make a decision containing a precise but narrow rule. The Supreme Court might still have specified, as in Miranda, close to the exact words that a warning would have to contain, but might have limited, as it did not, the cases to which those words would have to be given to a narrow class of police interrogations or to a narrow class of crimes. In such case, it would have selected an approach to rulemaking that was on the rules end of the rules standards continuum, but on the narrow end of the broad narrow one. And in doing so, it would have done something quite different from what was done in Miranda, where the court set forth a rule that was, like the class of insects, both broad and precise. Conversely, the court, in a different hypothetical variation on the real Miranda case, might have decided that flexibility was more important than guidance. It might have decided, for example, that it could not in 1966 predict all of the future possibilities for police conduct and misconduct, or that the case it had before it an actual controversy involving the state of Arizona and a particular individual named Ernesto Miranda in the context of a particular criminal case with particular facts did not provide sufficient information for the court to be making broad rules for the future. It might, therefore, have chosen to prefer something more like a standard than a rule. Confessions would be inadmissible if they were uninformed, for example. but it would still have had to make a choice about the scope of application of that standard. It might again have decided that the informed or uninformed standard would apply to all custodial interrogations, or it might have concluded that it would be best to restrict its application to a much narrower class of police actions. At times, the arguments for proceeding by way of a standard will be similar to those for deciding narrowly rather than broadly. Both are ways of leaving some determinations for the future. For example, but it is still the case that the question of the scope of a rule or a ruling is different from the question of its precision. Entire books could be written about the techniques of rulemaking, and indeed some of the manuals on legislative drafting come close to having this aim. But rulemaking is not just for legislatures, and once we recognize that courts as well as legislatures make law, and that courts as well as administrative agencies make rules, we can begin to think of judicial rulemaking as a task worthy of far closer attention than it has received to date.